Today I'm going to talk about Module 3 in the textbook, Social Psychology and the Law. Please note that there is no quiz associated with this chapter, but that you will be asked questions on the test. One of the ways that psychology is relevant to the courtroom involves eyewitness testimony, when someone has viewed a crime or other event and is called to court to testify about that experience. Because memory is a reconstruction rather than an exact duplicate of what happened, people often make errors in their identification of strangers in particular. For example, in 2005, Loftus and Harley found that accuracy in identifying celebrities began to drop at a distance exceeding 25 feet. It's not that people are lying, it's just that they remember things in their own particular way, which may not be exactly the same as how others see it. Believe it or not, people sometimes confess to crimes that they did not commit. In one study, the psychologist Saul Cassine found that more than 25% of people who were exonerated later confessed to a crime that they did not commit. Since over 90% of all felony cases are plea bargained, that is, the person agrees to plead guilty in exchange for a reduced sentence, the possibilities for error are significant. In a 1984 case, the man on the right, Ronald Cotton, was convicted based on eyewitness testimony of a crime committed by the man on the left, Bobby Poole. Mr. Cotton spent 11 years in prison before he was eventually exonerated by DNA evidence. Juries are an important part of the criminal justice process, and we like to think of them as being objective. However, this is not always so. Different juries can lead to different outcomes in the same case. For example, Ding et al. In 2020 found that people who feel vulnerable support harsher sentences, and Hetty and Eberhardt in 2014 found that perceiving the prison population as overwhelmingly black caused white San Franciscans to support more punitive punishments. One built-in problem with capital cases, that is, those in which the death penalty is an option, is that persons are not permitted to serve on the jury unless they agree that they will possibly impose the death penalty on a guilty defendant. However, these juries are inherently more likely to convict a given defendant than non-death qualified juries. The idea of punishment for crimes has a long history in Western jurisprudence. In our current justice system, we have two phases to a trial, one that determines the defendant's guilt or innocence, and a second that assigns a punishment to the person who is convicted. There are several functions for punishment. One is to cause people to make amends. Another is to avenge a prior deed. And a third is to deter others from committing similar crimes. In the United States, some people are disproportionately convicted and sentenced for crimes. We incarcerate a larger percentage of our citizens than any developed country outside of Russia. And black and Latino men are disproportionately represented in the U.S. prison population. Not only do people want to have the correct outcome in a case, but they want to feel like the procedure was fair. This is called procedural justice. Typically, three factors shape whether we sense that a hearing is a fair one. Is the authority figure neutral? Is the system trustworthy? And are we treated with dignity and respect? Unfortunately, these conditions are sometimes not met in our system, leading people to feel that the system itself is unfair to them. I hope you've enjoyed this short lecture and have enjoyed this course. As always, I invite you to contact me whenever you have questions or comments or concerns. I look forward to hearing from you. Take care.